There was a day and time when I used to do all kinds of webinars, and it's been a long time since I've done one. I'm glad to be doing this one. I'm glad that you are here and you're going to be part of it. And we'll get going here in just a moment. I am still looking at the attendance roster. I know how many registered, and there's still a few out there. While we're doing that, I could brag a little bit about what you see behind me. That is a picture of a program I lead, a curriculum opportunity for high school students called Student Senate. This is actually from the 2022 session, which is the 21st year I've offered this program. And I know that some of the people attending this webinar are looking at their own children right now because some of my parents are on this call. Student Senate is a 15-week semester-long program of miniature, if you will, legislative experience that teaches critical thinking, debate, persuasion, communication, and a whole lot of other skills. And it's probably almost the thing I enjoy doing the most with my life. So let's, I'll get out of the way. You can see some more of it. we were actually doing bill hearings. I think I probably need to turn that off. Excuse me. All these little things that ring, you know, when you're wanting things to be quiet. Thank you for your patience. I know that a lot of people on this, you know, that are attending the webinar know me, and they know my sense of humor, my odd style, and so forth. My friendly down-home guy. But a lot of you I can see I don't know. So thank you for being patient with me and putting up with who I am. Well, you don't know who I am yet. This is what we're going to be doing tonight. I have put together a slide presentation. I almost was just going to do this with notes, but I thought that probably we need to move in a certain logical direction. As I said, some of you on this call know me pretty well. A lot of you have never heard of me. And so just for a moment, if you don't mind, let me explain a little bit of why it's more than I stayed in a Holiday Inn Express, okay? Why I am able to do this teaching. First of all, if you really want to find out more, it's easy to find me, daveracer.com. I'm a teacher. I've been teaching almost 24 years now, American government, 21 years Student Senate, the Constitution, the Declaration, and a whole lot of other things. I'm a writer and author. I will be sending off my 54th and 55th books to the printer. I've written a great deal on healthcare and on public policy. I have spoken across the country. I'm a board member of Human Life Alliance. I was Alan Keyes' national campaign manager when he ran for president in 1996. I have been a candidate for office many times, and I consult on a lot of campaigns. I am the former chair and president of the Constitutional Education Foundation and the founding president of the Declaration Foundation. In between all that, of course, my wife and I have been married 55 years in August. I'm the father of 5 and the grandfather of 10. And a Christian fellow. So that's me, and enough about me. If you want to get hold of me, I'm going to show you how later on. And I got to give a disclaimer on this program. It's very, very important because what this is based on is the leaked first draft. And I want to make it clear that I, like you, consider the leakage of this draft to be a travesty that will forever tarnish the Supreme Court of the United States. And when they find the person who did this, I hope they severely punish them in whatever the law will allow, and certainly banish them from a courtroom. Wow, it's just unbelievable. Remember that these drafts, and this appears to be an early February draft, are passed around for each justice's arguments and comments. So the one that I reviewed, that some of you may have reviewed, is going to change. We just don't know how. Even if Samuel Alito makes no changes on his version, it is possible that each of the justices will create their own versions or pieces of that version to join into a majority opinion of some sort. The draft could change substantially. That's my point. And all of our excitement aside, it may not hold. It may be that what comes out at the end will not be a majority opinion. It will not do the things that this one promises to do. Got to understand that, be prepared for it. It was expected to be released in late June or early July. And of course, you recognize that's right in the middle of the election season. Now it has been released early and it's already an election issue. No matter the outcome of this decision, when it is finally released, it will generate division. It already has. It's been doing it for at least 50 years. It will generate division and start a new round of political activity. So this webinar, why didn't I wait until the final decision comes out and then do the webinar? Well, first of all, it's the teacher in me. When I read the decision, I said, oh my goodness, I could teach an entire course on the U.S. Constitution using this decision. That's how profound it is, and the arguments in it are incredible. So I had this in me. I had to do it. My teaching maybe can shut down some worthless speculation and unfounded lies, and maybe give some support to those of us who are pleased with the decision. And it does give us time to prepare when the final decision comes out. And so for me, it's a teaching moment. Teachers have to teach. Writers have to write. I teach and I write. And God impressed on me to do this. Now, actually, for several days, I thought, why am I doing this? And then I just said, I've got to do it. And because, look at this, moveon.org email, May 16th. This is yesterday. How did I get an moveon.org email? I subscribe to a lot of things so I can find out what the other side is doing. Look at what they wrote on this email. This weekend, over 1 million people joined Bands Off Our Bodies marches across the nation. And we should feel hope. Hope for a world where everyone has bodily autonomy. A world where they're inventing terms. A world where everyone is respected, valued, and has fully protected civil and human rights. I'll put a what do you call it, parentheses in there, if we let them live. I'm sorry, I shouldn't be doing that. After countless attacks on abortion and reproductive rights, people came together to declare that abortion is health care and to demand that our elected officials take action before it's too late. I have written 22 books on health care. 22. Never have I considered abortion healthcare. So what changed? How did we get to this place? Well, you know, it's actually simple and complicated. It happened because of these three who were appointed by this man who was elected by the people to be their president and were then approved by the Senate of the United States of America. Say what you want about some of them. This was tough work. This did not happen overnight. It has come as a result of decades of political activity by pro-life activists. And I hope now they'll get joined by constitutional activists to make sure that this moves ahead. This was a monumental change in the Supreme Court. And of course, if you watched what happened, especially to Kavanaugh, you understand why. And there was this law passed by a very courageous Mississippi legislature, Mississippi Code Section 41, 191 of 2019, the Gestational Age Act. And I'm going to read to you a couple of sections from the act itself. This is the language that created the lawsuit. Based on the findings in paragraph A, which we won't look at, which related to facts about abortion and how other jurisdictions deal with it, based on the findings in paragraph A of this subsection, it is the intent of the legislature through this section and any regulations and policies promulgated hereunder to restrict the practice of non-therapeutic or elective abortion to the period up to the 15th week of gestation. So no abortions would be allowed after the 15th week of gestation. Another section in the bill that I wanted to share with you, the law, I should say, except in a medical emergency or in the case of a severe fetal abnormality, a person shall not intentionally or knowingly perform or induce an abortion of an unborn human being if the probably, I wonder if that's a typo, probably mine. If the probable gestational age of the unborn human being, say it again, unborn human being has been determined to be greater than 15 weeks. Now, note, it does ban abortion, except in certain circumstances when the state says it is allowable. And note also, it's based on a political process of negotiation and persuasion based on deeply held beliefs and or political strategy. And it's different in Mississippi than it is in New York. Dobbs v. Jackson. Thomas E. Dobbs III, MD, MPH, that's a master's in public health, I believe, is the head of the state. He is the state health officer of the Mississippi Department of Health. He is an infectious diseases physician, board certified in internal medicine and infectious diseases, and he had been the district health officer and the state epidemiologist, which means he's had a lot of experience in public health and so forth. He's an associate professor at the University of Mississippi Medical School. The Jackson in the Dobbs v. Jackson Health Center is this clinic and its services. And I got this off their website. Jackson Women's Health Organization offers affordable abortion care to women living in Mississippi and or traveling to the state of Mississippi. And then it adds, we are the only abortion clinic in the state of Mississippi. All right, so now we know who the opponents are and what their claims are. Now, I am happy to send you, if you want it, a copy of the bill, a PDF copy. I'm not going to do it now. I'll do it later, maybe tomorrow. A copy of the bill and a copy of the Alito decision. So a copy of the bill itself and a copy of the Justice Alito's leaked decision. What you need to do is write to me at my email address, which is very easy to remember, dave@daveracer.com. I wanted to share here just a little bit. I think I'm going to stop sharing, and I hope I can come back to that spot. I have this document in front of me. This is really interesting from the bill itself, what they included in the bill. This is in the legal language of the bill that passed. The United States is one of only 7 nations in the world that permits non-therapeutic or elective abortion on demand after the 20th week. In fact, fully 75% of all nations do not permit abortion after 12 weeks gestation. So the Mississippi law doesn't even get us to those other 75% of nations, except to save the life and preserve the physical health of the mother. This is quite fascinating that they would put this in the bill. Here's a couple other things. Medical and other authorities now know more about human prenatal development than ever before, including that between 5 and 6 weeks gestation, an unborn human being's heart begins beating. An unborn human being begins to move about in the womb at approximately 8 weeks. At 9 weeks, all basic physiological functions are present. Teeth and eyes are present, as well as external genitalia. An unborn human being's vital organs begin to function at 10 weeks gestation. Hair, fingernails, and toenails also begin to form. At 11 weeks, an unborn human being's diaphragm is developing, and he or she may even hiccup. He or she is beginning to move about freely in the womb. At 12 weeks gestation, an unborn human being, notice they keep saying unborn human being, can open and close his or her fingers, starts to make sucking motions, and senses stimulation from the world outside the womb. Importantly, he or she has taken on the human form in all relevant aspects. And there's more. I'm frankly pretty impressed that the legislature put that in the law itself. So the law does educate. Moving on. So let's cut to the chase. This is the Supreme Court's finding if it holds, and it's expressed right at the beginning of the Alito decision. I'm going to read it to you. Maybe you'll cheer. We hold, if this holds, we hold that Roe and Casey must be overruled. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. Now, you can see why I, as a teacher of the Constitution, besides being very happy about this decision, also love the fact that it goes into how the Constitution is supposed to function, the Due Process Clause, and we will talk a little bit about that. And then at the end of the decision, it repeats this. We end this opinion where we began. Abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe and Casey arrogated that authority. It means they came against it. We now overrule those decisions and return that authority to the people and their elected representatives, and they could have said at the state level. Sending it back to the states. It's time to heed the Constitution and return the issue of abortion to the people's elected representatives. The permissibility of abortion and the limitations upon it are to be resolved like, listen now, like most important questions in our democracy. I could take some exception to this sentence. By citizens trying to persuade one another and then voting. That is what the Constitution and the rule of law demand. I don't like the word democracy. That's the modern term. I will not go into a lesson on that. And of course, the comma. But the real serious thing here is, and I'm going to throw you a little curve in a bit about this decision, but this is saying that the way we're going to move ahead on abortion now is by citizens deciding when a human being is a human being. Just think about that for a minute. So SCOTUS, as an unelected legislature, there is no constitutional basis for Roe. That's what the court just said. And this, I want you to know, is a critical comment, considering how the court has functioned for decades. And I'm not just talking about abortion. I'm talking about how the court has functioned as an unelected legislature. There are enumerated powers in the Constitution. The Constitution does not tell us what our rights are and our duties. The Constitution itself is a document of enumerated powers that limits government's reach. You've got to learn that. My students learn that early on when I teach this course. But in real life, it has been for decades and decades since the imposition of positive law. I think you can go back into the mid-1800s for this, when the court started to insinuate itself into what the words meant and change the words based on their own views. Maybe I'm talking into the 1920s and so forth. But there are many decisions that you can point to that show that the court lost the understanding of enumerated powers and instead began to see itself as the arbiter of what law is. Now, notice that if you read the Constitution and you read and I'm talking about also the Bill of Rights and all the amendments, the Constitution is silent on abortion, but the culture was not. This is what I teach my students, that the culture at the time of the writing of the Constitution was such that there was a Christian worldview that predominated. People thought, as a group of people, as an not an elective, as the citizens, as the residents, in the context of what was common in a Christian worldview. It doesn't mean they were all Christians, doesn't mean they didn't do unchristian things, believe me. It's in contrast to what we do today, which is a postmodern or post-postmodern way of thinking, where almost anything goes. So when those words were written, originally, they were written in the context of that Christian belief. Now, you have seen a fierce battle for decades now over this question of, were we a Christian nation or not a Christian nation? And I want to tell you that I teach that we were a nation founded with a Christian worldview. And it makes a difference. And here, this is a great example of it, because to throw out that argument to say that, no, we never were, we were, age of reason and all of this, throws out the moral basis of this decision. Now, realize that in issuing Roe and Casey, the Supreme Court of the United States acted as a legislative body. And one of the beauties of the Alito decision is how it explains that legislative bodies enact such things as, first trimester, second trimester, and all these rules. That's what goes into legislation. That's not what courts do. Justice Byron White called it an exercise of raw judicial power. And this is so important when you think about how legislatures, or not legislatures, how courts decide, making up rules and making up laws and instigating. I won't go into any of the others. There is a debate in the bill, in the decision itself, about other rights, and you are hearing the anti-Alito decision people saying, well, it's going to take away all kinds of rights. And it's very, very clear in this decision, they are only talking about abortion. And so consider it. I put this in here, consider NFIB versus Sebelius. That was 2012, and it was the decision that said that the Affordable Care Act was actually based on tax, and that's why they could force you to buy health insurance. My favorite judge on this said, if you adopt that logic, that means the Supreme Court can tell you, and the legislature, the Congress could tell you that you must eat broccoli. Well, this is the problem with judicial fiat. If the court can say that NFIB versus Sebelius is not a violation of your individual right to choose to buy health insurance, well, that's actually based on such things as the Roe decision and those that came long before it, where the court started determining powers. So the SCOTUS opinion had three rulings, the one we hope, that states, that is, they may or they are able to regulate abortions for their state. So therefore, this is the second one, Mississippi is allowed to regulate abortions for Mississippi, and that includes banning abortion after the 15th week of gestation. Notice that does not say banning abortion in every state. And they can act in protecting the life of the unborn. And third, Roe v. Wade and Planned Parenthood v. Casey are overturned because they arrogate the right of states to regulate abortion. That's what the decision accomplished in legal terms. It accomplished a lot more in terms of culture and politics. What Casey suggested was from the Casey decision, which was 19 years after the Roe decision, and used Roe v. Wade as a precedent, by the way, in making its decision. The Casey decision suggested that controlling opinion in that decision urged Americans to end their dispute and accept the court's decision as final. I just say, how did that work out? Now, Here's going to throw you a little bit of misdirection, something you may not have thought of. I will confess that, and I say this positively, I was a guest on Alan Key's TV show, as I am often, and we were talking specifically about this decision, and he said, everybody's so happy about this, and he said, am I the only one who has seen this and goes against the grain? It's not that he's not happy about the decision. It's not that I'm not happy about the decision. It's just that we are leaving it to politics, and that is a concern. The decision is based on something, it should be based on something other than politics, something that is above politics. And I just want you to think about this. I'm not going to spend a lot of time on it, just ruminate on it, because it's part of what we're going to have to do going ahead. We hold these truths, this is from the Declaration, to be self-evident that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. This is not an exhausted list, by the way, of the unalienable rights, but you do need to understand that it is very, very clear that the right to life, liberty, and pursuit of happiness does not come through the political process. It comes from God. It comes from the Creator. Life comes from God. Unalienable rights have their root in creation, not in a constitution. Constitutions like ours cannot grant rights nor take them away, except if doing it is unconstitutional, as they declared Roe to be. My students learn this. Government's purpose is to protect unalienable rights, not grant them. So what we've done is we are going to open up Roe v. Wade to the political process, and it is going to be properly addressed by states. That's what Roe said. So some states will ban abortions. My guess is Mississippi will be one of them. Some will apply rigorous regulations, but ban most of them. Some will choose loose regulations. Some will make sure abortions are legal. And you notice I brought up the seal of the great state of Minnesota, and I'll address that in a minute. Maybe some will choose to allow abortions even after a child is born, as we saw in Virginia, the attempt to do so. This is the danger, if you will, of making it a political issue. In my home state, and not everybody on this call is from Minnesota, our Attorney General, and I am paraphrasing, I am very sure that it's an accurate paraphrase, said that Minnesota will be a destination state. And he's not talking about the Mall of America or Mayo Clinic here. He's talking about Minnesota legalized abortion. And why is it? Why did that happen? What happened to make Minnesota a destination state? It was a Minnesota Supreme Court decision in 1995 called Doe v. Gomez. I remember it very well. I was doing talk radio at the time. I also ended up as a plaintiff trying to overturn it. So can Doe v. Gomez be overturned? And will it? It's a political process. Think about it. Minnesota has an elective Supreme Court. Minnesota could very well elect pro-life Supreme Court justices and district judges and appeals court judges. They could. We could. It's possible. And we could elect a pro-life governor and a pro-life Senate and pro-life House. By the way, when Roe v. Wade happened, there were a lot of pro-lifers on both sides of the aisle. What about your state? What's the layout, the political layout in your state? Now, SCOTUS in this decision discusses a lot of things that are very, very, very important. This is why I told you I was excited about it, because I get to teach constitutional principles, federalism and states' rights. The Constitution is a pact between states and we the people, and it outlined duties of the federal government and limited those and reserved the rest to the states and to the citizens. And so this is, in a sense, returning some of that power back to where it should have been all along. And I would think this would extend beyond abortion. It talks about the Bill of Rights and what the Bill of Rights is, that this is not an exhaustive list. And it was partly why, by the way, there was a big argument about whether there should be a Bill of Rights in the Constitution, because there was a fear that some would say, if a right's not in here, well, then it must not be a right. Or if a right's in here, then we should find a way to adapt it to other rights that are not mentioned. I mean, it's a little bit confusing. Now, I said, as it was during the 1960s debate, I will confess to you that I was a high school senior in 1965. I was already paying attention. This does not surprise my students, by the way. And I remember specifically the debate about legalizing abortion. I remember that the Republican Party in Minnesota was a leader in the pro-abortion movement. In fact, a very prominent woman of a very prominent businessman who went on to be a state senator was one of the founders of Planned Parenthood and a director and so forth. So the debate in the 60s was about legalizing abortion, and some states did, and people did start traveling, and the debate was ongoing in various states. So I have this reassertion of states' rights could possibly extend to other issues. Actually, this is a little out of order. I'm sorry, because I was trying to make the case that the debate was going on in the 60s, and Roe v. Wade truncated that debate by deciding that abortion was a federal right, and as it did with some other things recently that we aren't going to go into right now. It also means that states' election politics have suddenly become foremost for the 2022 election in particular, but ongoing. If Roe v. Wade stands, then abortion will become a central issue again. Right now in Minnesota, and I'm sure it's the same elsewhere, the primary issues are public safety and the economy, and then a whole bunch of other things. But those are the two most prominent. Just listen to the candidates, you'll figure it out. Well, abortion will now move to the forefront. You can't help it. Legislative action will now become the battlefield for abortion rights, or banning abortion or regulating abortion to the extent that it is nearly extinct. There are some, as I said, who will go ahead and try to ban all abortions in the state, and eventually I suppose that's where the battle is going to take itself. I read a piece, just a bit of it today, by David French. I won't go into it in depth, but he was talking about abolition, the abolition movement to abolish abortion altogether, and incrementalism. The idea being that incrementalism is more apt for elective politics because you do a little bit at a time. But the trouble is, each baby you kill along the way is still the death of a human being. So do we go for abolition outright if Minnesota goes pro-life, or do we do an incremental approach? It will require the governor's signature. So obviously, you can see already, if we're going to get a Roe v. Wade decision that overturns the decision, and the 2022 election goes to a pro-life House and a pro-life Senate and a pro-life governor, then something really spectacular might be happening a year from now. On the other hand, if any one of those three branches stays in the, I guess I should just say it, because right now the DFL, Democratic Farmer Labor Party, and the Democratic Party basically everywhere favors abortion rights, and the Republican Party does not. Basically, that's the way it lines up. Let's be frank. So it really, really, really is going to depend on this 2022 election, what's going to happen. When Keith Ellison says is the destination state, well, that's if things stay the same. So what does this mean? I wrote, based on who shows up and who's best at organizing. I wish that you all, maybe I shouldn't even say this because I'm going to destroy some of your perceptions, but politics is a lot about who shows up. I teach my students that the most important thing on election day is called get out to vote. Well, they've changed that now because we have early voting and mail-in ballots and all the things that we do now that make our elections kind of suspect, unfortunately. I hope we can get that straightened out for the next election. But the fact is, who shows up and actually votes, they're the ones that are going to elect the people that are going to make the difference. And so the campaigns that are best organized, best funded, and if you're listening to me, you may have to step up and help some of these people. They're the ones that are going to win. Now, here's the problem with this. This is a political process, which means that instead of basing the arguments on the fact that all human life is created by God, that it is not subject to electoral politics in that sense anyway, that's going to be lost because these arguments are going to be made on other things. They're going to be made on who can best secure the the safety and security of the people, who can provide a better economy, who can give parents some choice in their children's education, and on and on. It's not going to be based only on this issue, except for some people, by the way. Oh, I got ahead of myself again. Some people, by the way, are going to vote on this single issue. I've asked some of my expert friends who know this stuff really well if this still holds. It used to be that the pro-abortion side would turn out 6 to 8% based only on the abortion question, and the pro-life side would turn out 12 to 14 or 15%, which means that pro-life people tend to vote more when the issue is on the ballot in some way, shape, or form. But, we won't know that until election day. Unfortunately, that's going to all be based on the election. One of the arguments you're going to hear out there, by the way, that's surfacing now is that eventually, if this stands, if Roe v. Wade is overturned, then eventually they're going to try to get rid of contraception, same-sex marriage, and it goes on and on and on. And I read a fun piece today saying, contraception is never going to get to the Supreme Court. And it went into great detail why that's not going to happen. But in the decision itself, Mr. Alito very, very specifically said, this is only about abortion. This is not about these other issues. Now, in the decision, there's quite a discussion about rights, and especially fetal life or unborn human life, which are the terms that are used, and how these rights of fetal life or unborn human life are different from all other rights because they are inherent, they are unalienable, they cannot be compared with the other rights that we discuss in the Bill of Rights. It also talks about stare decisis, precedents, and that is one of the arguments that the the pro-Roe, the pro-Casey people argue that, Casey's based on precedents. Well, the precedent was Roe v. Wade. 19 years after Roe v. Wade, Casey quotes Roe as an established precedent, something that wasn't even in place for 20 years yet. That's not much of a precedent. Well, this decision says that Roe v. Wade is unconstitutional. You cannot use an unconstitutional decision and use that as a precedent. It can't continue to have standing if the decision itself, the original one, was unconstitutional. And abortion is not supported by any other precedents. This is what the decision says. Precedents have to be rooted in constitutional decisions, and precedents are overturned. Often they're overturned. It's not uncommon, let's put it that way. And then there's due process in the 14th Amendment, and the argument is very specific and it's deep, that these arguments about due process have to be rooted, and also in the next one, have to be rooted in our history and tradition. And it goes into great depth about common law arguments about murder and homicide and quickening, and that in the common law dating back far into 1500s. It quotes Blackstone and Koch and others. Well, actually, I can tell you this. I edited and published a book called A Treatise on Human Life for Dr. Harold Kletschka, where he goes back into, I kid you not, the 5th and 4th centuries and shows that common law prohibited abortion after quickening and still considered, even before quickening, to be a form of homicide. So our history and tradition and common law arguments are long-standing. The other one that the decision makes point of is that 3/4 of the states at adoption made abortion a crime at all stages of pregnancy. When the 14th Amendment passed, which I believe was 1868, it was a time where 3/4 of the states, when that was adopted, had made abortion a crime at all stages of pregnancy. So the history is not on their side. And then the issue of right to privacy, which was Casey's modification. Casey got rid of the trimester plan and talked about other ways to evaluate when abortion would be legal and not legal. But Roe, he says in his decision, expresses a feeling that it's expressed in the 14th Amendment, and other feelings are stitched together from the 1st, 4th, 5th, 9th, and 14th, and it makes it a very specious argument. These all need further study. If you're in my Constitution class next year, you can get that study. Before Roe, when the state politics were determining abortion law, 30 states had prohibited abortion at all stages. A third had liberalized the laws somewhat, allowing for some abortions. Roe stopped that process, and that created this huge chasm in our U.S. politics. What would have happened without Roe is a good question, going back again to the 60s and early 70s and the debates that were going on, even here in my state. I guess we don't really know, do we? I think probably we would have ended up, this is my speculation, somewhat like a Mason-Dixon line, where we had states that were totally pro-life that banned all abortions, and other states that will allow some, and other states will allow all, and we would have no unity in this country about this issue. So the question now is what will happen today after nearly 50 years of Roe v. Wade, and its proponents argue that it's deeply ensconced in our history now, in our tradition, and our culture. Well, guess what? We're going to have to develop a new one. It identifies 3 groups, and I thought this was kind of interesting, the way the language was. I write books, and so I was paying attention to language, and it said that there were 3 groups: those who believe, those who feel, and those who think. Apparently, believers and feelers don't think. I'm not real sure. But this is what it meant. The 3 groups: those who believe are folks who have a deeply held moral conviction about the origins of life, God as creator, and a personal responsibility to protect and advocate for life. I put myself in that category. This is the argument I made earlier. Then there are those who feel, and it was clearly referring to those who are pro-abortion advocates, folks who have done that. This is not a clear drawn in the sand line. These are generalizations. Folks who have an emotional investment in keeping abortion legal, even expanding it, feel it is a civil right about controlling their own body. And this is a very deep felt feeling and creates an immense amount of emotion. We have not seen, to my knowledge, a lot of pro-life people out throwing things and writing on walls and stuff. We have seen some indications of some violence out of the pro-abortion side. I suspect this will grow. I'm going to suggest to those of us who are pro-life, don't participate in that. And then there's those who apparently think, folks who reason that life should be protected. They might even be pro-life themselves as they say it, but they rationalize the meaning of law. So not to offend those who disagree, or maybe they don't want to be bothered. You'll hear this a lot from the so-called moderates. We won't get into all that political philosophy. Again, you have to come to my class if you want that. Folks who reason that life should be protected. I'm going to tell you, I won't give you his name, but I had a meeting 2 months ago with a person who was trying to make up his mind. Actually, it was January, trying to make up his mind about running for the state legislature as a Republican. He's a well-known grassroots populist activist who's taken significant stand on issues and is a hero somewhat to that movement. And I said, well, what about abortion? And he said, oh, I'm pro-life. I'm really pro-life. But you know what? I have no right to tell others what to think. And I said, oops, you're done. Well, that person got endorsed. So now he's confused because he has a primary challenger. You're going to find a lot of very careful examination. The voting bloc to whom folks think we have to appeal in this election are the thinkers, not the feelers, because they won't come our way anyway, or the believers who will be with us. I think you have to be pretty sincere about this. And the thinkers do need education. So what do we do now? And this picture represents a little bit of this person I was just mentioning. First of all, we got to recognize, whether we like it or not, this will be a political process. Winning the argument is a political argument. And we have to carefully identify candidates. We can't just say to someone, are you pro-life or pro-abortion? We have to go a little deeper when that person comes to your door. Now, you may be in a place where you have a candidate who you're not quite sure of, and then you have the one you're totally sure of because they're pro-abortion. You know, there you are. You have what some people call the evil of two lessers, but you have to choose one or the other. I know people always ask me, did I really say that? Yes, I did. I'm talking about choosing one or the other when you have no other choice. But you do have to carefully identify candidates. And then you have to get them elected. This is not a year to sit on the sidelines. You have no choice. If you believe in life, you've got to engage. And there's a lot of things you can do. And then you have to ride herd on them if they get elected. Believe me, once they get downtown, sometimes they forget. And then what do? We pray. This is a time for deep, serious prayer about life, prayer about our politics, prayer about our nation, and pray for the conversion, the salvation, if you will, of our opponents who do not believe in our God, who do not believe in our Christ. Pray for those people. I'm not going to say that by name, but we're told to do that. And then what can we do now? Well, we can educate and we can persuade. I really like this picture. I'm not sure who's arguing what. Maybe you can figure it out, but this is not a time to be silent. This is a time to educate. And if you are on the pro-life side, I want to tell you that you are on the right side. Don't apologize. I ran for office 4 times. The last time I ran was in 2002 for the Minnesota State Senate in Senate District 67, which is George Bush's base vote was 26%. That's what Republicans could pretty well count on. I ended up with 43%. And part of that was people who didn't want to vote for the first Hmong elected legislator. And I'm sorry for that, but that was their choice. I didn't have anything to do with that. But one day I was out campaigning. I was on the front steps of a person's house I'd never met before in South Maplewood. And he said to me, I have 3 questions. Okay, what's the first one? He said, where are you on gun control? And I said, well, everybody should be able to control their guns so they can hit the target. It's sort of a jocular way of saying I am pro Second Amendment, okay? I hope you chuckled a little. Then he said, where are you on the school referendum? And I said, at this time, I don't think our schools need more money. And by the way, she was leading the charge for that in the district. Then he said, how about abortion? And I've campaigned enough to know that, frankly, it's usually the pro-life people who ask that question, but I would give the same answer anyway. And my answer was, well, I don't back up from my pro-life stance. I am pro-life. And he said, well, I'm sorry you lost it on that one. And I said, well, I'm not changing. And he said, okay, but I'm going to get you 9 votes on this corner. And I tell you that story because you don't know, for most people, what's really going to motivate them. And so when you talk to people, be kind, be gracious, tell them your belief. That's all you can do is witness to your own belief, but, maybe get a little better educated on it. When the final decision comes out, I'll do a brush up on this and we'll get really educated. So that's about 45 minutes. I guess it's 10 minutes to the hour. Some people have, wow, those are some interesting comments. I just wondered if any of you have a question. You have to put it up in the Q&A, I guess, because I don't have a way to recognize your questions. Otherwise, I'm the only one that can see them. And if you do not at this point, I hope that I have not disappointed you, that you have heard the things that you were hoping to hear, or at least gotten started. I will tell you that this is an ongoing discussion. There will be much more to discuss going ahead. I am not the only person capable of doing this, obviously, but I do intend to stay on it. Thank you. Thank you so much for being part of this. Can I urge you to do something? Can I urge you to go to daveracer.com? I'm going to send you a thank you note. I guess I have your emails for attending also. And I'm going to mention something about Student Senate that I hope you will take a look at. But for now, it looks like I've done my job. This was recorded, and so we will make it available to people who could not be with us, and maybe it'll make a difference. Thank you so much. God bless you, and God bless America.